Hi, my name is Hamilton Davison. I'm the president of the American Catalog Mailers Association, and I'm going to be your moderator for today's press conference on the courthouse steps of the Supreme Court after the Quill decision has just been heard, South Dakota versus Wayfair et al. And I'd like to first introduce the counsel for Wayfair et al., George Isaacson.
Thank you, Ham.
George, were you surprised by the questions today? Were they what you expected?
Well, first, I was very impressed with the preparation that the judges had coming into this hearing. I thought their questions were pointed. I thought they reflected a full understanding of the briefs that had been submitted. And what was most encouraging, I think a real skepticism on their part of what the world would look like if 12,000 tax jurisdictions could require small, medium, or even larger companies to collect sales tax throughout the country. I think they had a real understanding of the fact that the crazy quilt that we have today is not well suited to the health of the economy, and that they would do further damage by a reversal of Quill. So I'm optimistic that their view will be that Quill was well founded when it was decided, and that any solution should be a congressional solution and not one by the court.
So they seem to be concerned about what the implications of their decision might be, and you certainly talked about that in some of your comments.
I think they really were. They're concerned about the potential retroactive application of states going after companies for back taxes. I don't think they were satisfied that there's an easy solution to that. I think they were concerned about the obligations that companies would have being overwhelming. I think they're also concerned that the state just did not present a record to them of information that would justify overturning the Quill decision.
And what do you think? What do you think the court would seem concerned about if they didn't overturn Quill? They talked a little bit about what the implications if they did. What is their concerns if they did not?
Yeah. I think they recognize the fact that this is a problem that warrants a solution. The states have an interest in acquiring revenue on those sales that are not currently subject to sales tax, even if that amount is smaller than the state's claim and is in fact declining in its amount. Nonetheless, I think they're sympathetic to the fact that the states have a legitimate interest, and I think they're especially sympathetic to the notion that if there is going to be collection by literally thousands, tens of thousands of companies, that it requires simplification of state sales and use tax systems. And I think the result of not overturning Quill would be Congress being able to move forward and come up with a compromised and balanced solution.
Counsel, you've done great work in this. Thank you very much.
Thank you, Ham.
I'd like to introduce Jonathan Johnson, a board member from Overstock.com, one of the respondents.
Yes.
Welcome.
Thank you. You know, we're pleased to be here at this place because we want to be involved in setting the course on this. And we've been working for over a decade trying to get Congress to act. And I think one of the important things we heard in the questions from the justices today is, can we make Congress act? And I think the court rightly understands that they can invite Congress to act and that Congress's inaction is a form of action. That's the right role for the court. What Congress needs to do is actually get out there and act. And I think that if this case is affirmed, the states will come to the table. They've been unwilling to come to the table for a number of years. And so, you know, I'm hopeful that the court affirms what the South Dakota court did.
So you favor a legislative solution to this problem?
We love a legislative solution. You know, today it's difficult because we are defending ourselves in state after state as they take a patchwork quilt approach of largely unconstitutional laws, and we win, but it's expensive to win. We would like certainty and we'd like simplicity, which is what Congress should be trying to achieve.
You'd like everybody to play by the same rules on the same day?
Same rules, same day, in a way that's fair for remote sellers, brick and mortar sellers, and omni-channel sellers.
Great.
Great,
Okay.
Thank you, Hamilton.
Thanks for joining us today. We also have with us former Governor Jim Gilmore of Virginia. Governor?
I'm Jim Gilmore, the former governor of Virginia. I was chairman of the National Advisory Panel on internet commerce that was set up by the Internet Tax Freedom Act that was established through the leadership of Congressman Chris Cox. He and I are the amicus in this case. We stand for the proposition that the Quill decision should be upheld. It should be upheld because of two reasons. First of all, small internet organizations across the country will be unduly burdened. They will be driven out of business. It's bad for the consumer. It's bad for the economy, and it's not healthy for the United States. That was the decision that we reached in the Internet Commerce Commission back in the year 2000 when we issued a report that said that if you're going to tax these small businesses, that you've got to have some simplification of this so that the burden is not undue and driving people out of business. The second point that I'd make as a former Attorney General of the state of Virginia is that the court relies, the people of the United States rely upon the previous decisions of the court. It's called stare decisis. Once a decision is made, then people are entitled to rely on that. And over this past 20 years, 25 years, people have invested millions of dollars and relied upon the court's Quill decision in what they have done. And now all of a sudden to overturn that, make them subject to retroactive taxation, to waste all their investment, to change consumer practices would be a violation of the fundamental rule of stare decisis, which means that the court should allow their decisions to be relied upon and to be firmly stated unless there's a radical reason for overturning it.
So people could get hurt here if this isn't handled properly.
If this isn't handled properly, I think that this is going to disrupt internet commerce in this country, which is a powerful driver of the economy and American power across the world.
Thank you, Governor. And I'd also like to introduce former Congressman Chris Cox, who, Mr. Cox, you've done quite a bit of work on this effort as well.
Yes, Governor Gilmore just mentioned the Internet Tax Freedom Act. It was signed in 1998. It was a huge bipartisan accomplishment. It passed the House of Representatives unanimously. It passed the United States Senate with over 90 out of 100 votes. It was signed by a Democratic president. It was enacted by a Republican majority Congress, but as I said, in huge bipartisan fashion. That legislation had one purpose. It was to make sure that with what at the time were over 10,000 taxing jurisdictions in America, now it's over 12,000, but with over 12,000 now jurisdictions, you wouldn't have internet commerce stifled because a business located in only one place has to now comply because it has a website with the tax rules of so many different states and their sub-jurisdictions. The Internet Tax Freedom Act was enacted after the Supreme Court's decision that we hope will be upheld today. And at the time, I said on the floor of the House of Representatives that it was a fundamental purpose of the legislation to make sure that Quill, the Supreme Court's decision that is at issue here, remains the law of the land by dint of Congress exercising its Article I power over interstate commerce, unless and until Congress changes that rule. The court today heard arguments on both sides of this case. It heard arguments from the state of South Dakota that the state should be able to reach all across America to small businesses everywhere. Those same arguments were made at the time that Congress considered the Internet Tax Freedom Act. We thought it was more important to promote the growth in the economy that would result from internet commerce. And what we've seen is that state sales and use tax collections, the very subject of this lawsuit, are up now in this year of 2017, or this past year, 2017, higher than ever before. South Dakota has had revenues growing at 4 or 5% a year, faster by far than the rate of growth in its economy, because of internet sales contributing use taxes that it didn't used to collect. It's been a revenue windfall. So it is absolutely imperative that small businesses, which right now are a great source of vitality in this economy, are able to continue without the burdens of complying with over 12,000 jurisdictions.
You've both done great work here in this area. I appreciate it. I'd also like to now turn it over to my colleague, Steve Del Bianco from NetChoice, who has joined me in a number of these legal actions throughout the state. Steve, you want to comment?
Thank you. Steve Del Bianco of NetChoice. And in that courtroom today, we've heard the most serious and significant interstate commerce case in a generation. And amidst all of that seriousness, we had the Trump administration suggest that what this court should do is preserve the quill protections, but only for businesses that take their orders only through mail order. The Trump administration is suggesting that the minute a seller puts up a website and takes an online order, they lose the protections of quill and would be forced to deal with 12,000 jurisdictions in 46 different states. So we'll watch the Twitter feed from the White House later today and watch for the hashtag Make Mail Order Great Again. I'd also like to introduce Kathy Terrell, a small seller from New York City, to talk about the real impact to a real business.
Hi, I'm Kathy Terrell, and I'm an online seller out of Manhattan, New York City. I sell online. I'm really looking at that I am protected by the Quill decision, and I'm protected by the bullying tactics of state government. If Quill is overturned, sales tax becomes weaponized against the hundreds and thousands of small businesses like myself. It is in effect taxation without representation, and that is un-American and it is unfair. What I'm looking for is the Supreme Court to uphold the Quill decision and strongly reaffirm their support of American small business.
Thank you,
My
Kathy.
pleasure.
I'd also like to introduce Tim Matthews, the president and CEO of Jewelry Television, another seller. Welcome, Tim.
Thank you, Hamilton. My name is Tim Matthews. I'm the CEO and president of Jewelry Television. We're a small company, employee-owned in Knoxville, Tennessee. We employ 1,500 employees, and we do business in all 50 states. We've been doing business in all 50 states in the shadow of the Quill decision because our business was started in 1993 through television broadcast, not the internet. And through our television broadcast, we reach over 1 million customers today. We actually reach 85 million homes, and we have over 1 million wonderful customers that we serve. These customers would be severely hurt if the Quill decision were overturned, and so we're very pleased to have been a part of filing an amicus brief before the Supreme Court supporting the respondent's position in this matter. I think one of the things that I will point out is that the oversimplification of the cost of compliance has been rampant in the case by South Dakota and the other proponents of overturning Quill. Nothing could be further from the truth. Let me give you an anecdote to illustrate my point. 10 years ago, we hired a very large, unnamed U.S. corporation. It would be a household name to any of you if I told you who it was, to implement a new warehouse management system at Jewelry Television. But because our systems had evolved over 15 or 16 years and contained a lot of very proprietary features, that software implementation, which we were told would be simple and could be completed in 7 months, turned out to be an utter disaster. It turned out that every claim about how simple it was to implement software turned out to be false. Last summer, we finally got a jury verdict in a U.S. district court for $39 million against that company for fraud, negligent misrepresentation, and breach of contract. And the point of that story is that things that are made out to be simple are hardly ever exactly so. And this is especially true when it comes to complicated software. Our company's software system has over 10 million lines of computer code. We have 4 different selling systems. We have selling systems for the internet sales, for our mobile application, for our express ordering system, which is a touch-tone system, and also the system that we use to take calls in our call center. So all 4 of those systems are impacted by a change in the law where we would have to collect the tax on behalf of the states. I also think that many of the non-technological issues were grossly oversimplified by the petitioner. For example, the issue of audit, paperwork, integration, maintenance, all the rules that are constantly changing, and applying all of those different rules against 12,000 different jurisdictions means that what you would have is a virtual nightmare for many small businesses in America. So I would urge simplification. I think that is the real ticket, the real answer here. It's not with the courts. It's not the judicial prerogative to decide how to fashion a new tax scheme. That's left up to Congress, better left up to Congress or the states to figure out. But simplification would be my byword.
Thank you, Tim. As a matter of fact, you bring up a good point. The other side would have you believe that it's just as simple as plugging in software and that creates a level playing field. Actually, creating a level playing field as it applies to us would be having every retailer check the driver's license of everyone that comes in their store and apply the correct local and state sales tax with the right product definitions remitted to the correct address with the correct forms and the correct sales tax holidays and the correct rates. And that complexity is the issue that we're dealing with here from the perspective of remote sellers. Thank you for joining us today. This concludes our press conference.